I've worn this robe for 34 years, long enough to know that justice is not only about statutes, video evidence, or what the docket records. It's about decisions. It's about what a person chooses to do in those brief 4 seconds when they believe no one is watching. And on a clear Tuesday morning in September, a case appeared on my docket that, on paper, seemed like a simple property damage issue. The clerk placed the file in front of me. Serena Wolf, 24 years old, reckless driving, failure to stop, resisting an officer. I read her name. Then I noticed who her father was. The moment she entered the courtroom, I sensed a shift in the atmosphere. Some defendants arrived nervous. Some appeared defeated. Others present a kind of practiced remorse, clearly prepared with their attorneys. Serena Wolf entered differently, like someone who had already spoken with someone she believed held more authority than anyone in the room. She was 17 minutes late. She did not rush. The pale blue cashmere sweater was carefully chosen, formal enough to show respect, composed enough to suggest she expected this to be brief. Her dark hair was worn down. Her steps and heels were steady and unhurried. It was the composed presence of someone familiar with official settings, someone who understood exactly how to present confidence. There was no apology in her posture because she did not expect one to be necessary. What she truly brought into my courtroom was not the sweater or the confidence, it was her father's name. And she carried it the way some people carry status, not openly displayed, but present, influencing the room before she even spoke. I waited until she reached her table. Ms. Wolf, you were scheduled for 9 mois. It is now 9:17. Is there a reason the court was kept waiting? She looked up calmly, with the quiet patience of someone explaining something obvious. I had difficulty with parking. No, Your Honor. There was no apology, only a measured response. The kind of answer given when someone has already decided the situation does not require more. Her attorney quickly stepped forward. Your Honor, we sincerely apologize. I acknowledged him with a nod, then turned my attention back to Serena. Ms. Wolf, this is a court of law. When it begins at 9, you are expected to be here at 9. Is that understood? She held my gaze for a moment longer than necessary. Then, of course, there was her father, Chief Raymond Wolf. He had served 16 years as the city's chief of police, making him the longest-serving chief in the department's recorded history. His photograph is displayed in the lobby of every precinct across the city. His name carries a certain weight here, one that tends to influence institutional systems before anyone consciously chooses to respond. Serena had grown up within that influence. This morning, she arrived carrying it with her. She was accompanied by 2 attorneys. Philip Crane, lead counsel from a firm known for representing the police union and the city's pension board. The second was her personal attorney, whose separate presence suggested Serena understood, at least to some extent, that this situation might require her to answer questions independently. In the 4th row of the gallery sat Edward Pike and his wife Lucia, who had driven in from the Millbrook neighborhood, where they have run their grocery store for 31 years. Edward wore a button-down shirt and a light jacket, the kind chosen by someone who had closed his store to attend court. Lucia held a notepad on her lap, though she had not yet begun writing. 2 rows behind them, in plain clothes, sat Officer Dana Reyes. She was not scheduled to testify that day. She was there in the quiet, deliberate way people attend when something they handled correctly is about to be evaluated, and they need to see whether it stands up. Before I could officially begin the proceedings, Philip Crane stood to address the court. He referred to the matter as a misunderstanding, challenged the description of the door contact as resistance, and added that Chief Wolf had submitted a character reference for his daughter and was available by phone should the court consider it necessary. He delivered that final point with a carefully measured ease, as though introducing a name that had often been enough in the past. I did not engage with that framing. Instead, I asked Sandra Cho to proceed. Without introduction, Sandra Cho presented the parking lot security footage. She allowed it to speak for itself, as clear footage does when it is simply played without interruption. The Mercedes entering the Millbrook Community Market parking lot. The recorded speed, 41 miles per hour, in an area marked for 15, the moment of collision. the rear corner of Edward Pike's delivery truck, the Mercedes side mirror breaking off, the visible shift of the truck on its frame. Then there were the 4 seconds at the exit, the store owner's face clearly visible in the frame. Edward Pike stood in the lot where he had just returned from a delivery run, looking straight at the vehicle that had just hit his truck. Those 4 seconds, the exit. I looked at Serena and asked if she disputed that her vehicle had struck the delivery truck. She replied with the calm clarity of someone explaining something she believed was already obvious. There may have been contact. It was not significant. The truck was in her way, and she was running late. Her insurance covers minor parking lot contact. I said, "Ms. Wolf, the footage shows you making eye contact with the vehicle owner at the exit. You saw him. You then drove away. I want you to explain what you believed you were doing at that moment." She lifted one shoulder in a partial shrug, controlled enough to remain acceptable, yet dismissive enough to be understood by everyone in the room. I was late. I assumed the insurance process would take care of it. The insurance process requires you to remain at the scene and provide your information. I'm sure my father's office can assist with the information exchange. The room became still in a very particular way, the kind of silence that follows when it is clearly suggested, without hesitation, that different rules apply to the person speaking. I looked at her briefly, then said, "Ms. Wolf, your father's office is not a system for handling civil traffic matters in this courtroom. What it is, however, is the reason this court will now contact him directly on the record." Philip Crane stood up before I had even finished speaking. The objection came immediately and was professionally stated. The chief's availability had been offered as a courtesy, not as permission to conduct an unscheduled examination during an open proceeding. I asked my clerk for the phone number that Philip Crane himself had provided in his pretrial filing under the heading "Character Reference, Available for Court Contact." She read it aloud. I thanked her. Serena's posture shifted, not dramatically, as she was too composed for that, but noticeably. It was the subtle change of someone who expected a name to act as a shield and had just realized it would instead be examined. The call was placed on speaker in open court. Chief Raymond Wolf answered on the third ring. His voice reflected 16 years as the city's most senior law enforcement officer, measured, firm, and carrying the tone of someone accustomed to being called with purpose. He greeted the court and said he was glad to assist. He described his daughter as a good person who may have shown poor judgment and expressed confidence that the court would consider her background and his family's service to the city. I said, "Chief Wolf, I appreciate you taking this call. I want to ask you something directly. The officer who responded to the complaint involving your daughter was Officer Dana Reyes, a patrol officer in your department. Have you had any communication with Officer Reyes, her supervisors, or anyone in the department's chain of command regarding this matter since the citation was issued?" There was a pause. Chief Wolf stated that he may have informed her supervisor that he was aware of the situation and was monitoring it. I said, "Chief Wolf, I want the record to clearly reflect what you have just told this court. You contacted the supervisory chain of the officer who cited your daughter, who is the defendant in this matter, to indicate that you were aware of the situation and observing it. Do you understand what that communication represents in the context of this proceeding?" A longer pause followed. He said he understood how it might be interpreted. I replied, "I am not asking how it might be interpreted, Chief Wolf. I am asking you to explain what you intended that communication to convey." The silence that followed was deliberate, the kind of silence from someone being asked, on speaker in an open courtroom, to explain something he clearly understood at the time and still understands now, but hoped would never require public explanation. He finally said, "I wanted to ensure the situation was being handled properly." I responded, "Chief Wolf, the situation was already being handled properly." Officer Reyes filed a complete report, documented the vehicle contact and the statement made, and submitted the building security footage as supporting evidence. The process was functioning correctly before you contacted her supervisory chain. What your communication conveyed, regardless of your intent, was that a senior official was monitoring a case involving his own family member. This court will address that. I ended the call. Serena was looking toward the bench. She was no longer managing her posture. She sat still in the quiet realization of someone who had just seen the system she relied on shift beneath her in a single exchange. Sandra then requested to present one additional piece of evidence: the apartment building security camera recording. The audio captured from the camera above the door was clear and free from distortion. "Do you know who my father is? You will not have a job tomorrow." Serena's voice, unambiguous. The courtroom held it. Serena said she had been upset. She said she hadn't meant it literally. I said, "Ms. Wolf, Officer Reyes filed her report. She submitted the parking lot footage. She documented the door contact and the verbal statement. She did all of that without adjustment, despite a direct statement from you that she would lose her employment for doing so. This court wants Officer Reyes to know that this proceeding has noted what she did and how she did it." Sandra then addressed one remaining matter. In the 2 weeks between the citation and this proceeding, Edward Pike's delivery truck had remained out of service. His insurance company required the at-fault party's information to open a claim. Serena had not contacted Edward, had not contacted his insurance, and had not provided her information through any channel in the intervening 14 days. The documented lost delivery revenue across those 2 weeks was a 1,840. I looked at Edward Pike in the gallery and asked if he would like to address the court. Edward Pike stood. He is not a person who performs emotion, and he did not perform it now. He stood with the steadiness of someone who has been doing difficult things for a long time and has learned that the difficult things do not require an audience. He said he had owned the Millbrook Community Market for 31 years. He had paid his taxes and his employees and his vendors every week for 31 years without exception. He was not asking for anything beyond what the law already provides. Then he looked at Serena directly. "I just needed her to stay. That is all I needed, 30 seconds. She looked at me and she left anyway. I want her to understand that I saw her and she saw me and she left anyway." The room held that sentence the way rooms hold things that have been said with complete precision and require nothing added to them. I looked at Serena. "Ms. Wolf, you came into this room this morning operating on a specific assumption that your father's position meant this room would behave differently. Your attorney mentioned his availability. This court found it useful to take him up on that. What this court learned from that call has been referred to the Department's Office of Professional Standards for formal review. Your assumption did not protect you here. It became part of the record. I want you to think carefully about what you assumed this morning and why you assumed it, and whether you want to keep carrying that assumption into every room you enter for the rest of your life." The ruling was this: on the reckless driving charge, an $800 fine, full court costs, and a mandatory defensive driving course to be completed within 60 days. On the failure to stop, a $1,200 fine plus full restitution to Edward Pike, $4,200 in documented truck repair costs, and $1,840 in documented lost delivery revenue, totaling $6,040 to be paid within 30 days directly to Edward Pike. On the resisting charge, 60 days suspended, 18 months of formal probation, and mandatory completion of a law enforcement community relations program. Her driver's license suspended for 90 days beginning today. And then the addition I had been considering since the footage played, since the 4-second pause at the exit, since the face visible in frame, 30 hours of community service at the Millbrook Community Market, not a charitable donation, not a check, 30 hours of physical presence at that store, stocking shelves and assisting customers and learning from the inside what 31 years of a neighborhood business requires of the people who run it every day. Serena said, "You can't require me to." I said, "I can and I have." Philip Crane was on his feet immediately with detailed objections. I noted each one for the record. I did not change a single element of the ruling. The department's Office of Professional Standards opened a formal review within 48 hours of the court's referral. 2 members of Officer Reyes's supervisory chain had received direct communications from Chief Wolf following the citation. Both acknowledged being aware of the chief's interest in the matter. Both were formally counseled. Chief Raymond Wolf received a formal letter of reprimand, the first in 16 years of service, placed in his personnel file. He did not contest it. Officer Dana Reyes was not disciplined. She received a formal commendation for the completeness of her incident report and the quality of her supporting documentation. She continued her patrol assignment. Serena completed the defensive driving course within the 60-day window. She paid the full restitution to Edward Pike within 30 days, a check from her personal account with a handwritten note on plain paper. I should have stopped. Edward Pike did not frame the check. He framed the note. He put it behind the counter at the Millbrook Community Market in the same row as the family photographs. Serena completed all 30 hours of community service at the Millbrook Market. She arrived on time for every shift. She did not speak much in the first 2 weeks. In the third week, she helped Lucia Pike reorganize the back storage room and stayed 45 minutes past her required time to finish the job properly. When Lucia thanked her, Serena said, "I'm sorry I didn't stop." Lucia said, "I know." 6 months after sentencing, I read a notice in the municipal court's professional newsletter. The city's police department had implemented a new protocol requiring mandatory ethics training for any officer or senior official whose immediate family member receives a citation from a department employee. The protocol was attributed to findings from an OPS review. The review had been opened on a referral from this court. I keep that in the same drawer where I keep the things that remind me why I put the roll bond in the morning. The thing I think about most when I think about this case is not the ruling or the referral or the protocol. It is the parking lot footage, the 4 seconds at the exit, the face visible in frame, Edward Pike standing in his parking lot looking at her, her looking at him. 30 seconds was all he needed. That is the whole of it. I want to say something directly to everyone watching this. This story is not about a police chief or a daughter or a parking lot collision. It is about something that happens every day in cities everywhere, a name that causes systems to adjust before anyone consciously decides to adjust. The adjustment doesn't require a phone call. It doesn't require a threat. It happens in the ambient pressure of a name that has functioned long enough in enough rooms that the rooms begin to anticipate it. Dana Reyes filed a complete report anyway. Edward Pike memorized the first 4 characters of a license plate and called from the landline anyway. They both understood that what came next would depend entirely on whether the room they reached would read what they brought. This room read it. Chief Wolf's contact with the supervisory chain became part of the record. His daughter's assumption became part of the record. The note behind the counter at the Millbrook Community Market says, "I should have stopped." That note, framed next to the family photographs, is what justice actually looks like when it functions, not as punishment, but as a 30-second accounting that someone was finally asked to make. That is what this bench is for, not for the name on the precinct photograph. For Edward Pike, for Lucia, for Dana Reyes, who filed her report and submitted the footage and waited to see whether it held. It held. Share this. Subscribe. Justice still has a pulse. It was always meant for everyone, not just the people whose fathers have photographs in lobbies.